Auzubillahiminash-shaytanir-rajim. Bismillahir-Rahmanir-Rahim. Dear students, Assalamu alaikum. We are discussing about organizational framework of the United Nations, or structure of the United Nations, or principal organs of the United Nations. I have already explained you about four major organs of the United Nations: the General Assembly, the Security Council, the Economic and Social Council, the Trusteeship Council, and Trusteeship System. Our today's discussion is about fifth major important organ of the United Nations, International Court of Justice. The International Court of Justice is the principal judicial organ of the United Nations. First of all, I explained you about its composition, its membership. It works according to the statute which forms an integral part of the United Nations Charter. The statute of the International Court of Justice is based on the statute of the Permanent Court of International Justice, which was prepared by the League of the Nations Council and unanimously approved by the League of the Nations in 1920. It is very important to note that after the Second World War, several members pleaded for the continuance of the Permanent Court of International Justice on account of good work done by this body. International Court of Justice and its membership aspect is very important. All the members of the United Nations are ipso facto members of the International Court of Justice. Ipso facto members mean all members of the United Nations are automatically become the members of the International Court of Justice. A state which is not a member of the United Nations can also become a party to the statute of the International Court of Justice upon the recommendations of the Security Councils. The conditions for membership in each case are determined by the General Assembly. The conditions which have been laid down by the General Assembly for membership of the Council include acceptance of the statute and other obligations with respect to the court which other members of the United Nations have accepted, and undertaking to contribute to the expenses an amount assessed by the General Assembly after consultation with the government concerned. The court consists of 15 judges elected by the General Assembly and the Security Council voting independently. These judges are elected not on the basis of nationality but on the basis of their qualifications and high moral character. Care is also taken to ensure that all the principal legal systems of the worked get represented in the World Court. Further, it has been provided that two judges cannot be nationals of the same state. All this has been designed to ensure that no one country or group dominates the courts. As regards the method of election of the judges of International Court of Justice, the initiative is taken by the Secretary General of the United Nations, who addresses a written request to the states which are parties to present statute and to the members of the national groups, asking them to nominate persons in a position to accept the duties of a member of the court. These groups can nominate not more than 4 persons in consultation with the highest court of justice, its legal faculties and schools of law. On the basis of the names thus submitted, the General Assembly of the United Nations and prepares a list of the persons in alphabetical order. Thereafter, the General Secretary and the Security Council proceed independent of each other to elect 15 of these candidates. The candidates receiving absolute majority of vote in both the General Assembly and the Security Council are considered elected as judges. Tenure of the judges. The judges of the International Court of Justice are elected for tenure of 9 years. However, they are eligible for re-election. The term of the judges is so ranged in the level that the tenure of only 5 judges expires after even 3 years. So, tenure of the judges and procedures of the judges' tenure is also considered very important. The vacancies thus falling vacant are also filled through regular elections. A judge elected to replace an other member holds office for the remainder of his term. It is noted that though the judge of International Court of Justice are taken from various states and the governments of these states take part in the nomination and election of these judges, but after their election the judges do not act as representatives of the respective countries, nor do they act upon the instruction of their government. They are treated as officials of the international judiciary and act accordingly. In fact, each member of the court, before entering upon his office, has to take a solemn declaration in the open court that he would exercise his power impartially and consciously. If we examine the seat of the court, the International Court of Justice has its permanent seat in session except during the period of vacations. Generally, the cases are heard by the full court, but it can also from chambers composed of these 3 or 4 judges to deal with specific categories of cases. The quorum of the court is 9. This implies that at least 9 members must be present to hold the meeting of the court. The court elects its own president and vice president for a term of 3 years. Both these officials are eligible for the election. In addition to this, the court appoints a registrar and such other officers as may deem necessary. The salary allowances of these officials are determined by the General Assembly and cannot be changed to this disadvantage during their term of office. The members of the court are entitled to pension on retirement. The statute is absolutely silent about the retirement age of the judges of International Court of Justice. The court takes all decisions by majority vote or of the judges present and voting. The president of the court does not exercise his vote except in case of a tie. It may be noted that no party enjoys veto with regard to the decisions of the court. The statute also provision regarding the removal of judges. A judge can be removed from his office only by the unanimous vote of the other members of the court. Now we examine about functions and powers of the International Court of Justice. It is very important that the International Court of Justice enjoys 2 types of powers. Number 1, settlement of dispute, and number 2, advisory opinion. First of all, I explain you about settlement of dispute. The court hears all cases involving sovereign states which have accepted the statute of the court. The other states can also take their disputes to the court on fulfillment of conditions laid down by the Security Council. It may be noted here that there is no provision for automatic reference of the dispute to the court. The United Nations Charter imposes an obligation on the members to seek specific settlement of international disputes, which implies that the parties can make use of their other judicial procedures also for the settlement of their disputes. However, the Charter enjoins on the members that they should, as a matter of general rule, refer legal disputes to the International Court of Justice. Though the court does not enjoy and compulsory jurisdiction, it is very important point of this discussion. I repeat it again, that the court does not enjoy and compulsory jurisdiction. The states parties to the present statute may at any time declare that they recognize as compulsory ipso facto and without special agreement in relations to any other state accepting the same obligation, the jurisdiction of the court in all legal disputes concerning the interpretation of a treaty, any question of international law, the existence of any fact which, if established, would constitute a breach of an international obligation, the nature of extent or reparation to be made for the breach of an international obligation. In simple words, the statute permits the states to concede compulsory jurisdiction to the court either conditionally or unconditionally. Such an authority may be conceded for any length of period. It may be noted that usually the states conceding compulsory jurisdiction to the court impose the conditions of reciprocity, which means that they accept the compulsory jurisdiction of the court in a particular case on the condition that the other party to the dispute would also accept it. The court also decided the cases referred to it in accordance with international law, according to international conventions and the general principles law recognized by civilized nations. In addition to this, the court also makes of judicial decisions and techniques of highly qualified publicists of various countries to determine the rules of law. The court is not bound by its earlier decisions and can look fresh at the new cases. The court does not enjoy any enforcement power. It is also a very important point that the court does not enjoy any enforcement power. It has to mainly rely on two factors for enforcement of its decisions. Firstly, each member of the United Nations has an obligation to comply with the decision of the court in any case to which it is under. This implies is that once a state has agreed to submit the case to the court, it would accept the decision of the court. Secondly, the Security Council can undertake enforcement action to give effect to the judgments of the courts. The United Nations Charter clearly stipulates that if any party to a case fails to perform the obligations incumbent upon it under a judgment rendered by the court, the other party may have recourse to the Security Council, which may, if it deems necessary, make recommendations or decide upon measures to be taken to give effect to the judgment. Second most important function and power of the International Court of Justice is about advisory opinion. The International Court of Justice also enjoys power to give advisory opinion to the General Assembly and the Security Council and other specialized agencies of the United Nations on legal question. While seeking advisory opinion, the agency has to submit in writing the request containing an exact statement of the question upon which an opinion required, as well as all the documents likely to throw light upon the question. This means that the court does not render advisory opinion on its own. Further, the advice of the court is not binding on the organ seeking it. In fact, the opinion given by the court is more like an advice rather than decision. While discussing about different function and powers, composition, membership of the International Court of Justice, after examining different aspects of the functioning of International Court of Justice, now we conclude and we assess its functioning that since the inauguration of the International Court of Justice in 1946, many cases and many disputes were referred to International Court of Justice. Out of these, different cases were subsequently withdrawn or removed from the list from various reasons, while in the other cases of the court found that they did not enjoy jurisdiction over them. So, some cases which were handled by the court covered a wide range of topics, and the court, after due deliberations, gave its judgment in different cases. If we analyze functioning of the court, then we find out that the record of International Court of Justice has not been very impressive. Only a limited category of cases are brought before the court. Even the number of cases which are being brought before the court has considerably declined. Further, the lack of enforcement. Due to the lack of enforcement power, also rendered the working of the court and court considered as a less effective. It is true that under Article 94 of the United Nations Charter, the Security Council can decide upon measures to be taken to give effect to the judgments of the court, but it has never done so. This has naturally given rise to many doubts about the desirability of taking the dispute to the International Court of Justice. Instead, states have preferred to take recourse to political settlement of disputes. This, however, does not take away from the importance of the court. Due to many critical aspects, due to vested interest of member states, and due to politics among states, court face many problems. But in spite of all these reasons, in spite of some shortcomings of International Court of Justice, it does not mean that importance of the court can be limited, because it cannot be denied that the court, through its valuable judgments, has contributed to the growth of international law and contributed to the establishment of more lawful world community in which mutual obligations are recognized. It is a different matter that to the majority of the people of the third world countries and also convince those from the developing countries that the law applied provides for change as well as stability and reflects the sense of justice. It must attach greater importance to the principle of equity in its judgments. While concluding this topic, it can be said that International Court of Justice as a judicial organ playing very important role in the system of United Nations or in the functioning of United Nations. While concluding remarks, Professor Nicholas explained his views about the contributions, about the value, about the importance of International Court of Justice in these words. And despite the court's acknowledges merits, it has been far from fulfilling the high hopes entertained for it in some quarters at San Francisco and afterwards, that its record to date is actually less impressive than that of its predecessors. The volume of business has been smaller and the cases that have been brought the permanent court of justice. If we analyze views of Nicholas, then we find out that basic objectives, basic purposes, and high ambitions of the member states of United Nations not fulfilling, as I have earlier explained you, due to the lack of enforcement power, due to the non-serious behavior of states, and due to the national interest of the states, because United Nations and its all principal organs and International Court of Justice, all these are composed of sovereign member states, and every sovereign state always promoted and protected their own national, ideological, economic, and strategic and all type of their interests. So clash of national interests become a major source of implication of the judgments, decisions, advisory opinions of the International Court of Justice. So, I conclude this topic by explaining you that in spite of all these limitations, in spite of all these shortcomings, it cannot be denied that the court has contributed its basic, most important role in the functioning of United Nations and for the promotion of peace and justice and for the promotion of peaceful settlement of disputes among states. So that is the end of our today's discussion. Allah Hafiz.